in terms of why the difference. And again, it also evidentiary in terms of the standards for admissibility of evidence, whether it's hearsay or whether it's how it's obtained, whether by coercion, by whether constitutional rights apply or any other rights apply, is an issue that potentially distinguishes, in some ways statutorily distinguishes the military commissions from federal courts, and in some ways remains to be seen how it distinguishes in practical terms. In the context of why the difference? There is, I think, a mythology as to the advantages of military commissions. For one, that we hear a lot of, and it's based, I don't know whether it's based on a lack of education about how the federal system operates or just a denial of how the federal system operates, is the question of secrecy and intelligence information. The federal courts have a statute, the Classified Information Procedures Act, we call it CIPA, C-I-P-A, that controls the use of classified information in federal criminal cases. And the courts have a perfect record in preserving classified information through use of the statute. There is no danger that a terrorist is going to come into possession of that information because they don't have security clearances. No defendant in these cases has a security clearance. Only their lawyers have security clearances, and their lawyers are permitted to review these materials based on their promise, essentially their agreement, to keep them confidential and only among lawyers. And that is what has occurred in dozens and dozens of cases, both terrorism and non-terrorism cases. Any national security case, there are many espionage cases in which CIPA has been used as well. And originally, CIPA was designed for espionage purposes, not for terrorism purposes. But that is something that is used in the federal system on a regular basis now. But the other issue about it is the government always controls in federal cases the ultimate dissemination of classified information. So that if I get classified discovery from the government and I see something that I think is advantageous to my case, and I say I want to use this in the court to establish my defense or to rebut an allegation by the government has the right to say to the judge, no, the government has three choices. One is declassify, which is always a possibility because they may find that the information is not sufficiently sensitive to warrant keeping it secret. The second is the government can offer a substitution that would be declassified and used in lieu of the classified information. And the judge gets to decide whether the substitution is sufficient or not. I can object and I can say, well, it doesn't really do everything I want it to do, but the judge can say, no, I think it does. And if the judge doesn't, the government can appeal to the Court of Appeals, and this happened in the Moussaoui case. All of these things have happened in cases already. In the Moussaoui case, and I'll just give you an example, statements by detainees in U.S. custody who the U.S. didn't even acknowledge were in custody, people like, I think it was Khalid Sheikh Mohammed and Ramzi bin al-Shib, but I'm not sure because I just don't remember precisely, but there were other cases. There's a case called Paracha in New York where two of the detainees' statements were put in evidence, substituted by the government, that the judge found were sufficient to give the defendant due process. The government can refuse altogether to give up that information. The government didn't have to use those substitutions. The government could have said, no, not at all. If the government thought it was too sensitive. Now, the court can sanction the government, can say, okay. And in Moussaoui, initially what the judge said was, you can't use the death penalty and you can't use the 9/11 conspiracy to convict Moussaoui. The government appealed and won. And the judge had to adopt substitutions that the government had proposed, and the government was allowed to seek the death penalty and use 9/11 in the case. That's just one of the mythologies. Another is that the military commissions will be faster. Here we are 6 years later with 3 convictions, and if Hicks didn't plead guilty, and we might still have a case going in that context. Just from my personal experience, and these cases will drag on for so much longer than the closure that could be provided by a federal criminal trial, which does not have the issues of fundamental legitimacy that are challenged in the commissions and will continue to be challenged. And the difference, I think, is becoming more transparent as you hear more commentators speak. Those who want military commissions is really a dilution of defendants' rights, a dilution of the opportunity to defend yourself, to sort of prejudge these cases. And what you have is this sort of this topsy-turvy version of justice, which is the worst crimes with the highest stakes, not only for the defendant, but really for society as a whole, judged by a lower standard of proof and a lower standard of procedure. So that's the military commissions versus the federal courts.
Joshua, I have just one question. I mean, from the point of view of a defense attorney, I mean, all of those points are valid. But I'm interested in just briefly, just your thoughts about the purpose of having a public trial. And if that, not that the military commissions, or would it be public or wouldn't it, but what you actually think, or have you thought about the fact that we've had so many trials in the 90s that were international Islamic extremism cases where people who have done harm to Americans. And I'm just wondering, is there some benefit beyond protection of the rights of the defendants in the civilian courts that is beyond that for the society as a whole?
I think there are two important benefits among many of a public trial. And one, after 9/11, I think a significant part of marshaling international support for the U.S. response and the identification of al-Qaeda as responsible for 9/11 was in large part due to a public trial, the embassy bombings trial, which I participated in as a defense attorney. The vast majority of the 9/11 reports section on al-Qaeda and the history and evolution of al-Qaeda is culled. All the footnotes are from the testimony at the trial in the first half of 2001, which basically illuminated for those who were paying attention the nature of al-Qaeda, the existence of al-Qaeda. I have to tell you, I had journalists come to me before that trial started, international journalists who came to me before that trial started and said, don't you think that al-Qaeda is really a creation of the United States government designed to deflect attention and create another enemy now that the Soviets are no longer available? And by the end of that trial, I don't think anyone really could hold that point of view hearing the evidence in that trial. And the second part about public trials is I've heard people state that one of the advantages of a military commission is that we don't want to give terrorists a public forum or a soapbox in our federal courts, as if the military commissions haven't offered that more than federal courts ever would, in terms of a circus-like atmosphere where the defendants essentially have had a certain amount of control which they would not enjoy in federal court. But I offer the converse, which is that in the context of world opinion, in the context of where we stand now after 8 years of a failed policy in this regard, is I think we need the platform of a public trial as much or more than terrorists do to make our case to the world that we abide by the rule of law, that our judgments are accurate and reliable and just.